Good afternoon and welcome to this Workplace Info webinar exploring the new political landscape for Australian employers. I'm Ray Welling, the publisher of the Workplace Info and Workplace OHS digital information services for IR, HR and work safety professionals. And today we're going to look at how the recent change in government is likely to affect employers. Now that we finally have some certainty about who will be governing Australia for the next 3 years, the question on everyone's lips is, how is this going to affect my business? Although the Abbott government's legislative agenda is still a work in progress, we assembled a panel of experts today that can examine what's likely to happen in several key areas such as workplace relations, paid parental leave, bullying, tax, superannuation, vocational education and training, and apprenticeships. Our panel today is made up of Fair Work Act and work safety expert Lewis Izzo, who's Specialist Counsel for Workplace Relations for the law firm Australian Business Lawyers and Advisors. Tax Specialist Michael Darren, who's Managing Director of the Azure Group. Also from the Azure Group, we have Superannuation Specialist Norman Howe, who is Managing Partner of Azure Group Wealth. And speaking on changes to apprenticeships and vocational and educational training, we have Andrew Williams, who's General Manager of the Australian Business Apprenticeships Centre. Gentlemen, welcome. Now, before we get stuck into the discussion, I'd just like to point out that the information that's provided in this webinar today is general information only, so it does not take into account your own particular work situation or your objectives, your financial situation, and needs. Before acting on any information contained in this discussion, you should consider the appropriateness of the advice having regard to your own objectives, work, and financial situation and needs. Now, Lewis, let's just kick off the discussion with a look at likely changes to IR laws. As you know, there are a raft of new changes to legislation such as the Fair Work Act that were instituted by the previous government, and they were due to come into force in January next year. Now, are those changes still going to take place now that we've had a change of government?
Thanks, Ray. The likely answer to your question is yes, they are. The reality is that the Abbott government's legislative agenda in respect of the Fair Work laws and industrial relations, aside from a couple of exceptions, is not likely going to see much change until at least July next year. However, there's a couple of exceptions to that I'll probably add to. But in the short, the changes that we looked at, that the federal Labor government brought in their last few months of office, will likely stick around initially. And we might just take a look at what those changes are. The very first type of change, which a number of employers may have heard about, relates to new bullying laws that were passed by the federal parliament in the month or two leading up to the federal election. These bullying laws essentially provide employees in a workplace to be able to bring claims against their employer or individuals in the employer's premises who've engaged in conduct that's defined as bullying, and they can bring these claims to the Fair Work Commission. Now, the first thing, probably just to give everyone a quick summary of what's involved, the new statutory provisions that the Labor government brought in define bullying as repeated unreasonable behaviour towards a worker or group of workers which create a risk to health and safety. Now, the one particularly unique aspect of these bullying laws that distinguishes them from a number of other types of industrial relations procedures is that under these laws, employees can bring their bullying claim to the Fair Work Commission at any point in time. They don't have to go to Human Resources first or bring a complaint under their own internal policy. They don't have to exhaust any internal grievance procedure. They can file their bullying claims at any point in time, and from that moment, Fair Work must commence dealing with the bullying claim within 14 days. The reality about that type of provision is it does turn conventional dispute resolution in the workplace on its head, and that's because ordinarily, in terms of grievances and other dispute resolution procedures, often the Commission and the legislation likes to see employees firstly raising matters with their managers, then if that doesn't resolve there, you take it to the next line of management or perhaps to HR, and it's only if the matter is still not resolved after internal grievance or dispute resolution processes have been exhausted that we then see employees bringing claims externally, whether it be to human rights commissions or the Fair Work Commission. This is very different because it'll put human resources departments in many circumstances straight away, not in the role of an independent investigator looking into the complaint, but straight away they might find themselves, the first time they hear about the complaint, they're a defendant to a Fair Work claim. And so for that reason, they're particularly unique laws. And what's interesting is, although there was a fair bit of criticism of these types of provisions before they were passed with bipartisan support. So the Coalition supported the laws, the Labor government introduced them, and so we're unlikely to see any level of substantive change to the laws before they kick off on 1 January. You'll see from the slides there that we talk about the fact that Fair Work needs to deal with the complaint within 14 days. Although the Fair Work Commission cannot impose compensation orders or penalties, it can impose any order it considers appropriate to stop the bullying, and that's a relatively broad range of powers. They might be orders moving an employee from one particular division to another. They might be orders to stop particular behaviour. They might be orders to have an employer take certain steps to remedy or rectify the bullying conduct. So the Fair Work Commission will have very broad powers from the very first conference that it deals with in relation to these types of claims. If we look at the other type of changes that were brought in by the federal government just before the election, they also made changes to right of entry provisions for union officials. So as many employers may know, there's provisions in the Fair Work Act which entitle unions to come onto a work premises to hold discussions with employees. Alternatively, they can enter workplaces to investigate suspected breaches of industrial instruments, industrial laws, or work health and safety laws. What employers and unions both found became problematic was where employers and unions could not agree on the location where the discussions were to be held, in particular when union officials came on to the site. And so the federal government introduced laws that stated that if there can't be agreement as to where unions can hold discussions with the employees, then they should hold those discussions in a lunchroom or where employees ordinarily take their meals. Those new amendments will kick off as of 1 January 2014, and again, it does not appear that there'll be substantial changes to that from the coalition government. Where we do think that there will be changes is that the government will be introducing some minor amendments about when the union can enter the workplace. There's some provisions that they need to be covered by an enterprise agreement. The Abbott government's also looking at particular changes that require the unions to demonstrate that they have a lawful representative role in the workplace. So that is, it's trying to ensure that the unions do have a right to cover the employees that they're coming onto the workplace to discuss or have discussions with. Before we just move on to the other types of changes, just to focus on the bullying laws that we discussed previously, we mentioned that we're probably not likely going to see many changes from the Abbott government till at least after July next year. They have flagged that they may consider requiring employees to exhaust a complaints process with work health and safety regulators before the employers go to the Fair Work Commission. There is no indication in the Coalition's policy about when that type of change might be introduced into Parliament. We're aware that the Senate will not change in its composition until 1 July next year. At that time, we're going to see new Senate members, including members of the Palmer United Party, the Motoring Enthusiast Party, and some of the other minor parties. And it will be interesting to see the extent to which they're willing to assist the Abbott government to bring in some changes to laws like these, bullying laws, etc. I think that the current message for employers has to be that on the bullying front and the right of entry front, in terms of these legislative changes the Labor government's brought in, probably not likely to see any substantive change for some time. I think that's the main takeout. If we proceed on to other types of changes that we might see, the Abbott government is proposing to introduce guides for small business on how to employ new workers. It's talking about a dedicated small business helpline that'll be run out of the Office of the Fair Work Ombudsman to provide assistance to small businesses, a small business wage app to enable them to better identify which wages apply to particular employees. Those three types of things can be done without legislative amendment, and so we may see them coming in sooner rather than later. In respect of the last change referenced on your slide there about potential immunity from penalty prosecutions, that would require legislative amendment, and again, so in that type of scenario, we'd need to see whether, firstly, the minor parties would consent to that type of change going through, because it's unlikely that we'd see a Labor government agree to immunity from penalty prosecutions in respect of underpayments. So that's kind of some of the changes we're seeing in the small business sector. There are other types of changes that employers may have heard about. The biggest one that people would have heard about is the paid parental leave scheme. That's the third bullet point there on your slides, and that is a fundamental change to the way paid parental leave works. At present, it's going to go from an entitlement of 18 weeks pay at the federal minimum wage to 6 months pay based on employees' actual wage, with any maternity leave payments capped at $75,000. So that's a substantial change. The people may have heard in the press that there's indeed some members of the Coalition itself who think it's too generous and have voiced concerns about this scheme. It certainly remains to be seen whether the Abbott government will be able to win over either the Labor opposition or, again, the minority senators to try and have this legislation passed. It certainly won't happen until 1 July next year, one would think, unless the Abbott government can get the Labor Party on board.
Now, when you say 1 July next year, do you mean that they would start to introduce legislation or that it would actually take effect in 1 July? Probably won't introduce the legislation until 1 July, which is when we'll have a new Senate. So when I mention the 1 July date on a couple of occasions, it's predominantly influenced by the fact that we still have the Senate operating, that was kind of operating before the federal election. There will be a change in Senate membership as of 1 July next year. So that's when we're going to see a lot of, when we know that the structure of the Senate in that way, that's when the Coalition will have more ability to start to bring some of these changes through. In terms of other changes, there's been a lot of talk in the Coalition's policy about increasing employees' ability to access individual flexibility arrangements under modern awards and enterprise agreements. So it's possible that we will see employees being able to use these arrangements perhaps in a default way. You don't need specific permission under the award or the agreement. There will likely be more ability to use individual flexibility arrangements to vary the provisions of an award or enterprise agreement, provided the employee remains better off overall.
in terms of kind of rounding out the discussion on the IR front, the main thing that's probably helpful for employers to be conscious of is that there's a pretty clear indication in the Coalition's policy about where it's looking to head on IR. And in fact, I'll just read it out because it is quite notable. They've said the details of the Coalition's policy to improve the Fair Work laws are spelled out clearly in its policy document. Based on the laws as they stand now, the Coalition has no plans to make any other changes to the Fair Work laws. What's quite stark about that comment is that there really isn't much contained in the Coalition's IR policy. We've gone through some minor changes to flexibility. We've talked about the paid parental leave scheme, talked about some very minor tinkering with right of entry. We're really not talking about any substantive changes to the fundamental parts of the Fair Work Act. So we really are seeing, and this is certainly my view, I may be proven to be wrong, but it will likely be very much business as usual under the Fair Work Act for this first term of the Coalition government, and it is possible that they may go to a new election in, say, 3 years' time with a different IR policy, but for present purposes, it really does look like the Fair Work Act is here to stay for the next 3 years.
Right. Okay. Great. Well, thanks for that. Now, Lewis, if I could just ask you a couple of questions about a couple of the items that you were talking about. Now, some of these have come through from our webinar participants, and I neglected to mention at the beginning, if I can encourage you to post any questions that you might have in the chat box in the lower left-hand corner. We will try to get to some of these questions during the course of the discussion, and we'll have a question and answer period at the end as well. But just to raise a couple of points, there was someone who wanted a little bit of clarification with the parental leave policy around the amount of the salary that's covered. And they were asking the question, the $75,000, is that's the maximum amount of pay that could be paid out during the 6-month period, or was it the salary that was $75,000?
Yes, so it's the maximum amount that can be paid out over the 6-month period. So what we would have is employees earning, for instance, $150,000 are entitled to 6 months paid parental leave, which means that they would be entitled to a $75,000 payment. If you're earning more than $150,000, then your payment would be capped at $75,000 for 6 months. So someone who's earning $1 million a year would not get 6 months pay at $1 million. They get 6 months pay at the rate of $150,000 per year, or $75,000 for the 6 months.
Right. Okay. Now, another question that came through is someone was asking how does would the new plan apply to women who are unemployed at the time of the birth of their child, but they meet the income requirement for the previous financial year?
That's a good question. I must say that, and we haven't seen the legislation, so it's a difficult question to answer. But what I would say is that most of the entitlements derived relating to pregnancy, maternity leave, etc., generally require an employee to be employed for a period of, say, 12 months before they can access the entitlements, for instance, under the Fair Work Act. And there's similar provisions in terms of employees who can access entitlements under current paid parental leave schemes. So someone who is unemployed at the time of commencing maternity leave, I suspect will not have an entitlement to this type of paid parental leave.
Right, right, okay. And you mentioned earlier about the, whether in fact this provision would get through or not. I don't know, do you have an opinion on the likelihood or otherwise of that? I mean, because certainly there, as you say, there was a lot of pushback from within the Liberal Party that, whereas on the one hand they were, taking the Labor government to task for the amount of money they were spending on various things, but then this program was something that would actually cost several $billions a year, and then not knowing what's going to happen with the new Senate. What do you think that there's a likelihood that this legislation wouldn't even see the light of day?
It's a possibility. I mean, it has been one of the keystone policies of the Abbott government, and Tony Abbott in particular, who has now taken on responsibilities, I understand, as part of his portfolio. He's also the Minister for, I think, women's rights or gender equality or something to that extent. I believe he's taken kind of some of those functions into his own portfolio. So it would be a surprising outcome if it dropped away entirely. I think it's going to depend on winning over crossbenchers like the Palmer United Party and some of the other crossbenchers, the Liberal Democratic Party, that have come out over as a result of the election. It's difficult to know how those minor parties which don't have substantial policy platforms leading into the election on these type of or a specific level, how they will vote. I imagine it'll come down to bartering with people like Clive Palmer or others. And at this stage, it's very difficult to know how that might turn out. They don't appear to be the best of friends at this stage.
Yes, yeah. I guess it's watch this space with that one, as it is with so many other things. All right, well, thank you very much for that update, Lewis. Now, Andrew Williams, you're from the Australian Business Apprenticeship Centre. Let's take a look at apprenticeships and vocational training and education. Now, as with the IR regulations that we've just been talking about, there have been some significant changes in apprenticeship area put into train by the previous government, and there are now more changes that are mooted by the coalition, in their election policies. How is all that unfolding, and what are employers likely to see over the next few months?
Yeah, thanks very much, Ray. And I think Lewis, capped out his presentation with the right phrase, and that's watch this space. So there's quite a bit going on, and has been going on for a number of years. And what I've got up on the slide now is just a quick overview of what I'll go through over the next few minutes. So first of all, the graph on the screen there, that's straight from, it's available publicly through the National Centre for Vocation, Education and Research. And it shows how the apprenticeship and traineeship market's been trending over the last few years. And as you can see, it's quite a significant decline. That's been generally as a result of a series of ad hoc changes to policy, changes to funding, financial incentives that the government makes available to employers to take on apprenticeships and traineeships. So we've seen that decline, and we don't have the latest numbers just yet. So what you see on the screen is really the forecast or the trend estimates for the June quarter and the actuals for the March quarter.
What caused the increase, the big increase before the big decline?
That was driven largely by government incentives, incentivising through initiatives such as a Kickstart initiative to take on trade apprentices in certain skills needs occupations, and those incentives were taken away or removed around 2011, 2012, as well as reduction or removal of incentives for diploma qualifications, part-time qualifications, and most recently existing worker qualifications as well. So essentially they've had a cumulative effect, and probably since in the 12 months to March 13, we've seen traditional trade commencements reduced by under 1%, and non-trade commencements, which would be your traineeships, they've had the most significant drop of just over 13%. And we're eagerly anticipating to see what the September numbers look like and whether that trend estimate is moving in the right direction or not. As I mentioned a minute ago, the reform of the apprenticeship system's been underway for some time. The previous Rudd government initiated an expert panel report into the future of Australian apprenticeships, and those initiatives have really been drip-fed into the system over the last 2 or 3 years. And by that I'm saying that we've had the introduction of mentoring programs, we've had accelerated apprenticeships, which was really a phrase that was not generally accepted or acknowledged by industry, but something that Senator Evans, a previous minister, was quite passionate about. But essentially, it means competency-based completion. Whether apprentices need to do the 4 years or the 3 or 4 years, or whether they can be signed off as competent. And essentially, competency-based completion can actually mean longer apprenticeships too if you take it to the full extreme. And also the most recent Fair Work review into the apprentice wage case stemmed from this expert panel report, and I'll touch on that in a few minutes as well. And really the key themes of this paper and the subsequent reforms that have come from it have focused on issues such as how to improve information and marketing apprentices, better matching of apprentices to employers, greater ongoing support through the life of the apprentice, and really how to utilise technology more effectively in the process. And we're going to see that come through over the next year or two, we anticipate, when the new government I suspect will adopt many of the themes from the previous government, and we're now starting to see discussion and more reform coming through the Department of Industry, where the apprenticeships branch now resides. So we'll see greater emphasis on outcome-generating activities such as mentoring, such as pastoral care, and really that's aimed at helping apprentices and trainees get through the first year of their apprenticeship. And research is really quite powerful that if they get through the second year, then completion rates are north of 90%. So we're going to see a fair bit more activity in that, and there's no real insight as to, and no indication as to whether the coalition government is going to fundamentally change that. We expect that they won't, and they will. We expect that they will embrace many of the core themes, and the departmental officials are quite well progressed on that at the moment. I mentioned the Fair Work wage review a second ago, and many people will be aware that the Fair Work Commission handed down its decision regarding apprentices' wages and conditions. That happened towards the end of August, and that's going to increase the minimum award rates of pay for first and second year apprentices in many cases. So basically there's a number of key outcomes there, and special provisions being made in relation to rates of pay, wage protection for adult apprentices, also recommending that provision should be made for competency-based wage progression to be introduced into several modern awards, and for consideration to be given to its introduction to some of the other modern awards. Adjustments are also to be made in relation to apprentice conditions of employment, including those relating to travel costs, training time, payment of training fees, and also attendance at training. There's also touched on school-based apprentice wages, and yes, as I mentioned, significant changes to the apprentice wage rate. That's due to come into effect from the 1st of January next year, and I think every individual employer really needs to take advice and guidance from their industry association or their local body.
And on average, what percentage increases are they looking at for apprentice wages?
It really varies across industry, and there's quite a bit of detail that I haven't put up there in excessive detail, but it's really aimed at apprentices who finish school at after year 12, who stay beyond year 10, I meant, and then we're reading that it could be for hairdressers, for example, the award rate could go up as much as $130 a week, and in other trades it could go up by $45 a week. But what we do need to consider is that there are many apprentices out there already that are paid above awards. So that's why I'm saying that everybody really needs to, in the context of their own organisation. Many employers do pay above anyway. So really, it's just a matter of looking at it on a case-by-case basis.
Right. Okay.
Another one that's another impacting factor, not linked to the federal government, but for employers in New South Wales, is the vet reform that's going through the Department of Education and Communities in New South Wales. And part of that, the New South Wales IPART, Independent Pricing and Regulatory Tribunal, recently reviewed apprenticeship course fees as part of the broader Smart and Skilled reform agenda that the New South Wales government is underway. So Smart and Skilled is essentially a major reform of the New South Wales vocation education and training system. It will introduce an entitlement for entry-level training, provide income contingent loans for higher level qualifications, better information for consumers, and a quality framework for government-funded training. It will change the arrangement for funding and purchasing government-funded vocation training from what is now a largely supply-side model to a largely demand-side model. What that means is that more of the government-funded market will be consumer-driven, and students and employers will have more choice over the approved RTO, registered training organisation, that best meets their needs. So the IPART review has recommended that that fees, currently, entrant training fees are much more heavily subsidised than other vet students. So the IPART recommendation will be to move towards consistent arrangements that will see increases for apprentices and new, particularly those undertaking higher level qualification in a high-cost industry group. The slide says that that's due to be implemented on the 1st of July next year. About a day or so ago, we got word that that's been moved out again, and it's now earmarked to come into force around 1 January 2015. So it's an ongoing, and I think it initially started estimate would be 1 January 2014, so it's moved to 1 July and it's now moved to 1 January 2015. So we've got a bit more time to see the detail yet, and we haven't seen a great deal of detail from the New South Wales government on that.
And how does that state-based reform compare to other states? Is New South Wales at the forefront of this, or are they catching up to the others? Or
I don't think it's a matter of being at the forefront or catching up. Victoria went through something not dissimilar a year or two ago, and that caused quite a bit of disruption and uncertainty in the market. So, without having seen all the detail from the New South Wales reform yet, it would appear that they have actually, sat back, seen the example that came out of Victoria, maybe learned any of the lessons and been able to implement, some of the learnings from that. So, we're hoping that it won't cause as much disruption as it may have caused in Victoria. But, as I said, we haven't seen the detail yet, and we're looking forward to that.
Okay. And there was just briefly, there have been a couple of questions that have been coming in as well. Just to clarify, that when you're talking about apprentice wages, does that covers trainees as well? The changes to the wages, or not?
I haven't seen all the detail, but we believe it's just trade apprentices and particularly apprenticeships that are under the National Skills Needs occupation. So we're not, at this stage, I don't believe it's traineeships. It's just the trade apprentices.
Okay. Thanks.
And just finally, to give a bit of insight into the coalition election policy, I was just in a conference, my first meeting with the government officials this week. It was actually in Adelaide, and over Monday and Tuesday this week, and we're not really hearing a lot of detailed policy coming through the Department of Industry yet, as the new government's obviously getting established. So what I've got up here is really the core platform of the coalition election policy, and that's really been underpinned by what they're calling trade support loans, which is a $20,000 or up to a $20,000 income contingent loan that's spread over the 4 years, and that's income contingent, as I said, and it's anticipated. It's very similar to the HECS fees for university, and the threshold to commence the payback will be at just over $51,000, and that's aligned to trade occupations and apprenticeships that are on the National Skills Needs list, and the high priority qualifications. So there's no further guidance on when these loans will be introduced, how they will be administered, but it's most likely to be that it will be very similar to HECS and administered through the tax system. So again, to paraphrase Lewis, watch this space on that one as well.
Right. Okay. Well, thanks very much for that, Andrew. Now, Michael Darren, I might bring you into the discussion at this stage. Now, Michael's a chartered accountant who founded the Azure Group in 2002, and he's been their managing director and is also director and company secretary for several listed and unlisted public companies. So I just wanted to ask you a few questions, or get you to talk a little bit about the tax side of things. Now, the Coalition has had a number of things to say about the taxes affecting business during the election, but how's that landscape shaping up now that they've been in power for a few weeks?
Oh, well, what we've seen there already, Ray, and thanks for the introduction, is they're pretty determined to make some serious changes to the tax system. The Abbott government's already come out and has a very strong intention on abolishing both the carbon tax and the mining tax, repealing both taxes, and basically cutting red tape for small business, which is a good thing, certainly across all our team of corporate and CFO advisors. We're seeing much more confidence in the small business space amongst employers, and seeing that the government, with the introduction, for example, of a small business minister as part of the portfolio in the Abbott government, Mr. Bilson, being appointed, that there's a determination to support small business. Examples are like issuing a warning to go easy on independent contractors and the self-employed recently by Mr. Bilson. So, look, the focus, I think the three areas that are evident in terms of changes for this particular seminar that I'm seeing is, number one, there's a removing of the carbon tax and what that means for small business I can discuss in a moment. Number two, a clear initiative there is to cut the company tax rate by 1.5% from 30% to 28%, from 28.5% from 1 July 2015, and then, basically not pushing forward with the FBT changes that the Labor government had intended on introducing. So look, in terms of carbon tax, there's a clear intention there. So they're going to be abolishing the carbon tax. It will continue to apply for 2014 financial year, but the intention is that the bill gets repealed from 1 July 2014. That will still mean that there's going to be a compliance obligation for businesses under the carbon pricing mechanism, but that will sort of taper off and be finalised by sort of February 2015, that they won't need to deal with that any further. So the carbon tax is gone, Ray. No more carbon tax. And for small business, that just means, in terms of costs that they're currently incurring, which are tied in with carbon tax, that there should be benefits. Obviously, there's going to be benefit. Tony has come out and suggested that that's going to save, the household $550 a year in their electricity bill. So for businesses, it should be even bigger savings, but then savings in other areas as well.
So are they going to have to unwind all of those provisions that the Labor government put in place when they put the tax in, that tried to compensate different groups for the costs of the tax? I mean, I don't know, it seems really complex to me what they set up in the first place. So will they have, or will some of those benefits still remain in place even when the tax is gone?
Oh, look, the government obviously, changed some of the marginal tax rates, increased the low-income tax threshold up to $18,000, and basically those sorts of changes. There's no anticipated changes for that. So yeah, look, it's pretty clear. Tony Abbott intends to cut the carbon tax, but not necessarily wind back some of those other things. There's a couple of small areas where they're going to adjust, and I'll talk about those in a moment. But the other area, and one of the big areas, is the 1.5% cut to the company tax rate. So that's going to be a benefit for all employers that operate through a corporate structure. So that's a definite saving for someone with, say, $500,000 in profit. That's a saving of $7,500 straight to their bottom line. It does mean that with company tax rates, which is not, was a flat rate at 30%, it's going to drop to 28.5%. That a corporate structure is really relevant for people that are running businesses. through family trusts and other structures, it makes it a little bit trickier to access and have these profits sort of parked inside a corporate structure, say for your working capital within a business. It certainly benefits you if you've got a flat rate of 28.5%, whereas at an individual level, your individual rate's much higher. And then the third area is the Fringe Benefits Tax, where the Labor government had intended to abolish the statutory method, and the Abbott government doesn't intend to do that. So that just means that for people who, use cars and had the benefit through their employer to apply the statutory method and get a benefit out of the differential between fringe benefits tax that they pay versus the income tax they'd otherwise pay, that benefit's going to remain. And that had a significant impact across the car industry, put a lot of things on hold, and so, that's a good thing for employees and employers, that there won't be any changes on that front. Just a couple of points worth noting is that there's going to be an introduction of a 1.5% levy on companies with taxable income above $5 million to compensate or to fund essentially the paid parental leave scheme. They suggested there's about 3,000 companies that this would impact, but I have a feeling it's a lot more than 3,000 companies that make more than $5 million in profit. So that would have a broader range of impact on those companies. So there will be an additional levy. There won't be franking credits that flow through to individuals or to shareholders of those companies as part of that levy. So it's a real cost for companies with those levels of profits. The other things is there's an intention there that they'll repeal the loss carryback provisions where there was a benefit where if a company had losses that they could claw back taxes they paid in prior years on profits. And then a couple of other things where there was instant write-off on cars for $5,000 an instant write-off on cars, and also an instant write-off on asset purchases under $6,500 for SME businesses with turnover under $2 million. So a couple of things there. So they look like they won't continue, that small business won't continue to get those benefits, but offset in a large way by the reduction in the company tax rate. In essence, you're still going to be able to claim those costs on those assets. It will just be over a period of time rather than upfront. So small businesses are not losing a deduction. It's more of a timing impact, whereas the 1.5% cut is a real saving for small business. But, look, on my wish list, I'd like to see the small business threshold increase in terms of the cash basis for GST and income tax purposes increase from 2 million to 10 million. That was put in place a long time ago, and turnover of business has increased a lot since then. And back when the government introduced GST, there was an intention to remove a lot of non-value-added taxes, which still hasn't happened across state government. It was promised, it still hasn't happened. Continues to get deferred, and I think that needs to be reviewed as well as just trying to help small business with red tape. There's still too much red tape. For example, businesses with more than $75,000 turnover still need to do quarterly BAS returns. A simple measure might be to increase that turnover threshold to say $200,000 or $300,000. It just means less compliance costs, less cost for the really small business owners. But good that they've come out, and Mr. Bilson's come out to suggest that they want to sort of back off the small business subcontractors and let's support small business to be successful in the future.
Right. Now, Michael, I had a question that's come through from one of the participants. With regard with that levy to help fund the paid parental leave scheme, they asked the question: does that levy apply to not-for-profit organisations?
It's on your taxable income. So not-for-profit organisations don't pay don't pay tax, so it wouldn't apply to a not-for-profit organisation. It applies to taxable profits above $5 million.
All right, great. Okay, good. Thanks for clarifying that. All right. Now, finally, we wanted to take a look at the superannuation side of things, and for that, I'll turn to Norman Howe, who is also with the Azure Group, and he joined them this year after more than 25 years of financial services experience, specialising in wealth management and superannuation-related financial services. And Norman's also an authorised representative of Guardian FP Limited. Now, Norman, what superannuation changes are going to be likely happening that will affect employers?
Thanks, Ray. Super normally gets mucked around quite a lot, but thankfully it hasn't been too much tinkering. But there's some little sleepers in here that I'd like to draw your attention to. So let's have a look at what's going on. There's 4 aspects of this that you really need to know about as an employer, but also as an individual. So essentially, we knew that the SG contributions were going to continue to go up under the previous arrangements. That's not going to happen exactly the same way. So it's been frozen now, so it's 9.25 from the 1st of July, only for the next 2 years, and then it more than likely will go up. So that's a little bit of a break for most employers, where the expectation was that it's going to keep on going and all of those sorts of things. The other thing that has happened that might impact or will be good to know about is that there was mooted, and hasn't been legislated yet, proposals to start taxing super funds in the pension phase. Why I've got this on the slide here is this is the thin end of the wedge. When you consider that super controls about $1.7 billion at the minute, and around about 1/3 of that, $400 to $500 billion, is now controlled by self-managed super funds, you can see that super becomes easy picking. So just tuck that away, that if this taxation goes through, then at some point it's highly likely that the tax on super might increase. The other area that you might want to know about is the FOFA, the Future of Financial Advice. There's a raft of changes that came in 1st of July, and there's also another raft that are due to come in. The previous coalition, now the government, had a philosophical difference with Labor about how this should all be done. So essentially, there's still a bit of a fight. We haven't been able to get clarification yet as to how far the new government's going to go to start changing that back. But what we do know is that they are opposed completely to the opt-in requirements, and that's where planners need to be contacting their clients every 2 years. But some of the good things that are going to come out that we still think will happen is this simplification and the streamlining of the annual fee disclosure requirements, which is a good thing for everyone, and also about scaled advice, where you go and see an advisor and you don't get stitched up to be given advice about things you don't really need. And then also to have real clarity about what commissions someone can legitimately have and what commissions you really can't. Now, the other area that will impact everybody is this thing called SuperStream, bit of a sleeper. A lot of people don't know about it, but I'll come and talk about that a little bit later on, but it is going to impact everybody, both you as an employer and also all of your employees, and also you as an individual. So in real terms effects, really what's going to happen, a little bit on the cash flow, not quite as much as what might have been previously thought. What is going to happen, SuperStream is going to force you over the next couple of years to make changes to how you train people, payroll, how you pay super, and in particular when you're going to do that. And there's 4 significant dates that I'll talk about in just a sec. So really, what have you got to do? So you've got a bit of an idea of what's going on. With SuperStream, what it's doing, this is also a bit of a thin end of the wedge. Super and the way that we transact with super in the future is all going to be driven by the ATO. It's going to be standard messaging exchanges that everyone is going to have to comply with. And by July 2015, everybody, and I mean everybody, is going to be part of this. So where it'll impact you coming after December is that all of the super funds that have rollovers where you might get involved with or be asked to facilitate or things like that, they will all be digital. Most of them are now, and they will be. And what that means is that it's going to be turnaround times of about 3 days instead of all the mucking around that everyone goes on with now. July 2014, if you've got more than 20 employees, this will impact you, which means you now need to start to think about how you're going to implement this from January in terms of how my payroll system is going to be set up. Who's my provider? Are they doing it? What do I need to know about? And whether or not there's going to be a need to get someone to come in and help you with this, or whether you can do it yourself. But it is going to become a really big deal, because employees are going to be made aware during next year and the following year that they're going to have their own portal via the ATO, so they can move money around, see what's going on, employer of choice, fund of choice, all of those sorts of things. Self-managed super funds too next year. They are also going to be mandatorily driven to make all of their contributions via this same message exchange. And then 2015, mandatory. Everything. All employees, and particularly with people with 19 or less, you're going to be part of this regime as well, whether you like it or not. So just to be clear, by July 2015, you will not be able to pay any super at all, anyway, no checks, no transfers, only via the ATO portal. So that means it needs to be integrated with your payroll, and likewise virtually from now, any rollovers, that's all going to be digital. So if I had a bit of a crystal ball, where is super going to go, and how is it going to impact employers and that sort of stuff? Well, super, it's not going to impact you so much financially in a physical way, like you have to pay more except what you know about. It's going to be the hidden costs of getting involved with SuperStream, and also too whether or not you want to be an employer of choice and start making super and all those sorts of things part of your value proposition to people you want to attract. So what's really going to be happening? Basically, super via SMSFs is going to become more and more popular. You've no doubt seen a lot of media press lately, particularly with people roaming around wanting to put properties into SMSFs. We're getting inquiries almost daily now for people wanting to do that. So as an employer, or someone yourself looking at these arrangements, they're all going to be very much, I think, in front of mind, particularly next year, especially if we start to see property continuing to go the way that it is, and it becomes quite attractive for people who've got themselves and their partner, where between the two of them they've got nearly 200 grand. Let's go play and get our own self-managed super fund, and away we go. Just to give you an insight, there's coming up to 550,000 self-managed super funds, and it's growing 10 to 15% per annum. So more and more people are becoming aware of this and want to do it and take control, and that'll impact you. Salary packaging, there was a measure introduced as from the 1st of July where the maximum superannuation contribution limit for someone over 60 is now 35,000, not 25. And for the rest of us, it's all going to scale up over the next 5 or 6 years, where we'll get to that as well. So you might get more people wanting to look at salary packaging, or as an incentive, you might want to move that out as a bit of a way of retaining your top people. And there will be costs attached for you to perhaps look at upskilling people in your HR department, or bringing people in to have a chat about what this means and how you're going to go about doing these sorts of things. So in a nutshell, not too many changes to super, but there's some sleepers in there. You do need to know about SuperStream. It's going to be a big deal. If you want to be a little bit different from others, then getting some knowledge about self-managed super funds or salary packaging and things like that might help you become an employer of choice. Thanks, Ray.
Right. Well, thanks very much for that, Norm. Now, I just had one quick clarifying question that from your discussion that came through from one of the participants. Now, that delay in raising the superannuation guarantee, how did that happen without going through Parliament?
I know, it's still to be gazetted. Thanks for picking me up on that. Like we were saying before, a lot of this depends on what's going to happen during the next 12 months, but it's a stated thing that what we want to do is we want to repeal that. I want to change it. That first 100 days hasn't come up yet, so Tony and the boys haven't been able to get around it, but it's one of the things that they're committed to, because it goes a little bit hand in hand of a trade-off because of the carbon tax. Don't have quite as much money. We want to then make things a bit easier. So what we're going to do is we're going to bring this back and give, once again, in line with what Mr. Bilson was saying, we want to give small businesses a bit of a go.
just on that as well, it was going to be quite a hassle for a lot of small businesses to have to increase the super from 9.25 to 9.5 to 9.75 to 10 year on year, and administer that, and it meant updates to employment contracts. It meant all sorts of implications just for small business from an administration point of view when it was first introduced. And so that was just a significant burden on small business. So in one sense, that's a reduction of red tape, which is, there's a cash flow benefit, but there's also a red tape benefit for small business by the fact they don't have to worry about dealing with that year on year.
Right. Okay. No, that's a good point. Thanks for that.
And then it reverts back to the employee, like Norm suggested with salary packaging, where, look, if they want to put more in super, they still can. They just have to talk to their employer and say, well, let's reallocate some of my salary to super. I can up to, $25,000 or $35,000. It makes tax sense for me personally. I get ahead in life. I don't need to put that money towards my mortgage, and and everyone's happy. So, that in itself is a good thing, I think, for small business and for people.
Right. Okay. Well, thanks very much for all that, gentlemen. Now, looking at the clock, we've got just a couple of minutes for questions. So I might just throw a couple of questions in the mix. Now, one that's come through for you, Michael. You were speaking about the less red tape for small businesses, being what's likely to happen, and in particular with regards to contractors. Could you clarify a little bit about exactly what that means in terms of the government backing off contractors?
Oh, look, the government came out recently, and there was just discussion there where the ATO was, finding that some subcontractors, whether it was better for them to be treated as employees or as contractors, and it wasn't, allowing some contractors to apply for an ABN, and so there was obviously uproar for small business with that happening, and it was a bit of a heavy-handed approach that was sort of considered. So it's not necessarily any changes that are happening. It's more to do with the administration of the law by the ATO and other various bodies. So it was more or less just saying, look, let's back off. Let's give small business a chance. And, and with all our CFOs and all our advisors that are advising at the moment to try to get them ahead, help them become more profitable. Now, these are really critical things for business in terms of just not being, not having to go to bed at night with these worries on their shoulders.
Yeah, just feeding on what Michael said. It's an area we advise in as workplace relations lawyers a lot. We have employers coming to us indicating that they have, or principals coming to us indicating that they have various contractors for work. And often, although they believe they have a genuine contract arrangement, the test at law as to whether some employer or contractor is far more sophisticated than that, looks at all these indicia about level of control over the person performing the work, how they're paid, all sorts of different things. And we've noticed the ATO has looked into this a lot in terms of whether there should be superannuation payments being made to these contractors. And additionally, the Fair Work Ombudsman has the power to investigate and bring underpayment claims. And for many employers or small businesses out there, they don't actually realise they're in breach of the law until one of the regulators comes knocking. So it would be interesting to see if there's going to be, because I'd noticed there's been a little bit of rhetoric about it from the government as well. It'd be interesting to see if there's any attempt to legislate in this area to make it a bit more clear when someone is an employer, is a contractor. Today, it's very much been left up to the courts to determine, having a look at a whole range of all the factors in any particular case, weighing them all up, they then say, well, someone's a contractor or someone's an employee. That, although that works for us perhaps advising on which way a court may go, it's not very easy test to apply for the common small business. or even large business owner actually out there trying to work out how it should properly be engaging individuals.
Right, okay. Look, I think we've got time probably just for one more question. Lewis, I might ask you one. You spoke earlier about the changes to bullying regulations within the Fair Work Act. Somebody raised the point is they wondered what was the likelihood of the increase in vexatious claims because people would be allowed to, go straight to the commission rather than talking to the employer first. And then I guess the question that would follow on from there is, if that does come to pass, what options would the new government have for, changing that aspect of the regulation?
Yeah, that's a very pertinent question because the Fair Work Commission is, or the President of the Fair Work Commission, when these laws initially came out, had made some public comments and kind of overtures to the government about needing more resources to deal with these types of claims because if we take the number of unfair dismissal claims a year, there's about 14,500. A new type of proceeding was brought in about a few years ago called adverse action claims that relate to kind of employees' ability to freedom of association, things like that. And since their introduction, we've been seeing about 6,000 claims a year. So it wouldn't be unusual to expect something in the realm of 4,000 or 5,000 claims next year in relation to bullying. Now, that's a lot of claims. And in our experience, sometimes we do see vexatious claims where employees are being performance managed, and the response to performance management is, I'm being bullied. Now, the government has introduced an exemption to the bullying laws to state that reasonable performance management action does not constitute bullying. That doesn't necessarily mean that employers still won't bring those types of claims. And it'll be interesting to see how Fair Work deals with them, whether it does kind of dismiss performance management related matters relatively summarily at the beginning of the process. But I would expect that we'll see, if we do get 4,000 or 5,000 claims next year, which we might get something near that going through the Fair Work Commission, you will see a large number, maybe not the majority, but a significant number that relate to performance management, many of which may not be genuine bullying claims. I suppose we'll have to see whether the government will respond to that. It might. I just think that the Abbott governments can be very sensitive about being seen to be watering down the bullying laws because from a PR perspective, it's not necessarily the best look, and we know that the Abbott government is particularly sensitive to the IR, to making too many changes in the IR field because they don't want these allegations that Work Choices is back, things like that. So it's wait and see, but it may be something that's left to Fair Work to try and stamp out through its own processes and procedures.
Right, great. Thanks for that. Well, that brings us to the end of our discussion. Andrew, Lewis, Michael, Norman, many thanks for your time. We hope you found today's session useful. Please feel free to drop us a line at editor@workplaceinfo.com.au if you have any follow-up questions. And make sure you log on to Workplace Info and Workplace OHS for the latest info on compliance and best practices for HR, IR, and work safety professionals. If you want to revisit some of today's discussion, an archive will be published on our YouTube channel to watch and listen to at your leisure. The URL for that archive will be included in our follow-up correspondence. We've also got some upcoming webinars, which I really don't have time to go to in detail, but if you log on to the website, you'll see that some discussions we've got coming up on conflict and harmony in the workplace, bullying, and how to avoid problems at your upcoming work Christmas party.
That's excellent.
So I'd just like to thank everyone for your time, and best of luck with your work.
Thank you very much, Ray. That was excellent.
Thanks, Ray.